Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner.
In today's video, we are going to discuss one important topic that is from section 124 to 139 of Bharatiya Sakshya Adhiniyam of 2023, that is regarding witnesses.
Hello and welcome everyone. Today we're going to tackle section 124 of the new Bharatiya Sakshya Adhiniyam 2023. This section answers one of the most fundamental questions in evidence law. Who is actually allowed to give testimony in court? Now, for your judiciary and APO exams, this section is super important, so let's get right into it and understand it in detail. So, here's our game plan for this explainer. We'll start with the basics of witness competency, then we'll break down the key parts of section 124 itself. After that, we'll look at some real-world examples and landmark court rulings to see how it all works in practice. And of course, I'll wrap things up with some essential tips specifically for your exams.
All right, let's begin with the very foundation of this topic, the concept of witness competency.
You see, section 124 sets out a very clear and simple general rule. The law presumes, or basically assumes, that every single person is competent to be a witness. What this means is that if someone wants to claim a witness is incompetent, the burden of proving that is on them. So, to put that legal language into simple terms, the law's starting point is that everybody gets to testify. The only exception, the only time someone is stopped, is if the court believes they just can't understand the questions being asked, or they can't give logical, rational answers to those questions. Now, to get a better grip on this legal framework, let's break this section down into its most essential parts. There are really three key elements here. First, competent to testify. This just means you are legally qualified to give evidence. Second, understand questions. You need to have the mental capacity to get what's being asked of you. And third, give rational answers. Your responses need to be logical and make sense. These three pillars are the very foundation of witness competency. So in court, the judge follows a pretty logical three-step process. They start with the general rule, everyone is competent. Then they consider the exception. Is this person unable to understand or answer rationally? And finally, the judge makes the final call, usually after asking the witness a few preliminary questions to test their understanding. Now, here's what's really fascinating and a common point of confusion. The law is very clear about who is not automatically disqualified. Just because someone is a very young child or very old or has a physical or mental illness, none of that automatically makes them incompetent. The real test is always about their intellectual capacity at that moment, not about the label or condition they might have. Okay, so how does all this theory actually apply in a real courtroom? Let's explore the practical side of section 124. Let's take a classic example. Imagine a 7-year-old child witnesses a crime. Before the court takes their testimony, the judge will ask some simple preliminary questions. Things like, what's your name, or where do you go to school? Now, this isn't just small talk. The judge is trying to figure out if the child understands the difference between truth and lies, and if they can clearly explain what they saw. So, the big question is this 7-year-old a competent witness? The answer is absolutely yes, as long as they can understand the questions and give logical answers about what happened. Their age isn't the deciding factor. Their understanding is. Now let's look at how the judiciary has interpreted this section over the years. Some landmark cases have really clarified the entire concept of witness competency. On this topic, one of the most important judgments you need to know is Rameshwar versus the state of Rajasthan. This case is a cornerstone for understanding the testimony of a child witness, and it's absolutely crucial for your exams. In this landmark judgment, the Supreme Court held that a child's competency depends on their intellectual capacity, not their age. The court also clarified that if the judge is satisfied that the child understands their duty to tell the truth, then making them take an oath is not mandatory. This whole principle is perfectly summarized by a famous legal maxim: evidence must be weighed, not counted. What does that mean? It means the quality and reliability of the testimony are far more important than the number of witnesses. A single, reliable child witness can be much more valuable than several unreliable adult witnesses. To really nail this topic in your exams, you need to understand a few key legal distinctions related to Section 144. This is where you can score some serious points.
First, it's important to note that this isn't a completely new provision. It used to be Section 118 of the old Indian Evidence Act of 1872. Under the new law, the Bharatiya Sakshya Adhiniyam, it's now Section 124. The core principle, though, remains exactly the same.
Okay, this brings us to a critical distinction you absolutely must understand: the difference between competency and credibility. Think of it like this. Competency is a question of law, decided by Section 124. It asks, can this person even enter the witness box? On the other hand, credibility is a question of fact. It asks, now that they're in the box, should we believe what they're saying? From an exam point of view, for your prelims, you can expect a direct question on Section 124. For mains, be prepared for a short note on a child witness or a problem-based question, where you'll be given a scenario and asked to determine a witness's competency. All right, let's do a quick revision. Just remember these three things. 1, the section number is 124. 2, the core concept is that everyone is competent unless they can't understand or answer rationally. And 3, the key principle is that competency is about the ability to testify, not the believability of the testimony. For more legal content focused on judiciary, APO, and other law exams, please stay connected with us here at Ganga Education.
Hello and welcome. Today, we're going to be breaking down a really crucial Section 125. This section deals with the testimony of witnesses who can't speak, which, as you know, makes it a very significant topic for both judiciary and APO examinations. So let's dive right in.
You know, the entire philosophy behind Section 125 is summed up perfectly by this simple phrase: disability is not disqualification. The law makes it very clear that justice can't be denied to someone just because they are unable to speak. It's really about creating an inclusive approach within our legal process.
So, here's our roadmap for today. We'll start with the core principle behind Section 125. Then, we'll decode the language of the BEAR Act itself. After that, we'll look at how it actually works in a courtroom, examine some key judgments, discuss the safeguards and its legal value, and finally, we'll wrap up with the most important takeaways for your exams. So, what's the big idea here? It's actually quite straightforward. The fundamental principle of Section 125 is that the law cares about the content of the communication, not the way it's delivered. The main goal is just to understand the testimony, whether it's spoken, written down, or even conveyed through signs. Okay, now let's get into the nitty-gritty and look at the actual legal language. We'll turn to the BEAR Act to see exactly how this principle is written into the law. Section 125 says, and I quote, "A witness who is unable to speak may give his evidence in any other manner in which he can make it intelligible." So, in simple terms, what does this mean? It means if a witness can't speak, they can use writing or signs to give their testimony. The only condition is that whatever method they use, it has to be understandable to the court. To really get a grip on this section, we need to break down its key components. Let's look at these key words. First, we have unable to speak, which covers anyone who is nonverbal or has a speech impairment. Second, intelligible manner, which just means the evidence has to be clear, like through writing or signs. Third, in open court, which is absolutely vital for transparency. Fourth, and this is a big one, any evidence given this way is legally considered oral evidence. And finally, the proviso, which makes it mandatory to have an interpreter and to video record the proceedings. So that's the theory. But how does all of this actually work in practice? How do we go from the principle on paper to a procedure in the courtroom? Let's take a look. The process is actually very systematic. First, the court establishes that the witness is unable to speak. Second, the witness gives their testimony using writing or signs. Third, and this is so important, the court brings in a special educator or an interpreter to help. Fourth, as we just mentioned, the entire thing has to be videographed, that's mandatory. And finally, once recorded, this evidence is officially treated as oral evidence. Let's use a practical example to make this crystal clear. Picture a criminal case where the main witness is both deaf and nonverbal. That witness would use sign language to give their testimony. A sign language expert would be in court to interpret those signs for the official record, and the whole process would be recorded on video. That's a textbook application of Section 125. You know, it's one thing to read a section in a book, but it's another to see how it's been interpreted by the courts. That's where the real meaning comes to life. So let's look at how our courts have viewed Section 125 over the years. All right, let's look at a few landmark judgments. In State of Rajasthan versus Darshan Singh, the court made it very clear that just because a person can't speak, it doesn't make them an incompetent witness. Then, in Misala Ramakrishnan versus State of AP, the court confirmed that evidence through signs is perfectly valid, but they also stressed how important proper interpretation is. And finally, in State of Maharashtra versus Bandhu, the court really emphasized that this kind of evidence needs to be recorded with extreme care and precision.
And this whole idea perfectly illustrates a fundamental principle of natural justice, which is captured by the legal maxim audi alteram partem. It's Latin for let the other side be heard. Section 125 is a beautiful example of this principle in action, making sure every single person gets a fair chance to be heard in court, no matter their physical abilities.
Now, let's talk about the safeguards and the evidentiary value. It's great that the law provides this option, but what measures are actually in place to make sure it's used fairly and reliably? So why are these safeguards, like an open court, interpreters, and videography, so critical? Well, there's a real risk of misinterpreting signs or gestures. There's also a chance of manipulation or coercion. So the whole point of these safeguards is to make sure the evidence that's being recorded is both authentic and completely accurate. Now, here's a point you absolutely have to remember for your exams, the evidentiary value. Any evidence given under Section 125 is legally considered oral evidence. This means it carries the exact same legal weight as testimony that is spoken out loud. It's not a lesser or secondary form of evidence in any way. Okay, let's switch gears now and get into a pure exam-focused mode. What are the absolute must-knows from this section for your judiciary and APO exams? This is a really important update you need to know about the new criminal laws. Under the old Indian Evidence Act of 1872, this provision was Section 125. But now, under the new Bharatiya Sakshya Adhiniyam of 2023, the same provision is found in Section 136. Please make a note of this. It's a very likely question for your upcoming exams. And here's a direct tip for you. In your prelims, you could easily get a direct question on the section number or its proviso. Something like, under which section is videography mandatory? For the mains, you should be prepared for a short note on the evidence of a non-verbal witness, or even a problem-based question. All right, let's do a super quick revision. Just remember these three key things. First, the section number, 125 of the Indian Evidence Act. Second, the core concept, evidence from someone who can't speak is treated as oral evidence. And third, the key safeguards, an open court, an interpreter, and mandatory videography. And as you can see, its importance for exams is very, very high. And that concludes our deep dive into Section 125. It's really so much more than just a rule of procedure. It's a powerful statement about equality and access to justice. This provision ensures that our courtrooms are places where every single voice, no matter how it's expressed, can truly be heard. We hope this analysis has been valuable for your exam preparation. For more judiciary and law exam-focused content, stay connected with Ganga Education.
नमस्ते एवरीवन और गंगा एजुकेशन में आपका बहुत स्वागत है। आज हम जुडिशरी और एपीओ एग्जाम्स के लिए एक बहुत ही इंपॉर्टेंट सेक्शन को डिस्कस करेंगे जो आपकी प्रेपरेशन को थोड़ा और आसान बना देगा। तो आज हम जिस टॉपिक पर बात करने वाले हैं वो है सेक्शन 126। ये सेक्शन डील करता है हस्बैंड और वाइफ की विटनेस के तौर पर कॉम्पिटेंसी से, यानी उनकी गवाही देने की कैपेसिटी से। ट्रस्ट मी, एग्जाम्स में ये टॉपिक बार बार पूछा जाता है।
तो चलिए सबसे पहले इस सेक्शन के कोर कीवर्ड कॉम्पिटेंसी को आसान भाषा में समझते हैं। लीगल टर्म्स में कॉम्पिटेंसी का सिंपल सा मतलब है कोर्ट में एविडेंस देने की कानूनी क्षमता, यानी एलिजिबिलिटी। सेक्शन 126 ये बिल्कुल साफ कर देता है कि सिर्फ इस ग्राउंड पर कि दो लोग शादीशुदा हैं, उनमें से किसी को भी गवाही देने से डिस्क्वालीफाइड नहीं किया जा सकता। अब ये काफी इंटरेस्टिंग है। अगर हम हिस्ट्री देखें तो पुराने इंग्लिश लॉ में हस्बैंड और वाइफ को एक सिंगल लीगल एंटिटी माना जाता था और इसी वजह से वो एक दूसरे के अगेंस्ट गवाही दे ही नहीं सकते थे। लेकिन मॉडर्न इंडियन लॉ ने इस पुराने रूल को छोड़ दिया और एक बहुत ही प्रैक्टिकल और जस्टिस ओरिएंटेड अप्रोच अपनाया, जहां स्पाउसेस को इंडिपेंडेंट इंडिविजुअल्स माना जाता है और उनकी टेस्टिमनी सच तक पहुंचने के लिए जरूरी समझी जाती है। चलिए अब देखते हैं कि बैर एक्ट की लैंग्वेज आखिर कहती क्या है। देखिए, सेक्शन बिल्कुल साफ साफ कहता है कि सिविल प्रोसीडिंग्स में सूट के पार्टीज और उनके स्पाउसेस कॉम्पिटेंट विटनेसेस होंगे। ठीक इसी तरह क्रिमिनल प्रोसीडिंग्स में एक्यूज्ड का हस्बैंड या वाइफ भी एक कॉम्पिटेंट विटनेस होगा। तो यहाँ पे नोटिस करने वाली बात यह है कि ये रूल सिविल और क्रिमिनल दोनों तरह के केसेस में इक्वली अप्लाई होता है। सो लेट्स ब्रेक इट डाउन इनटू टू सिंपल पार्ट्स। सेक्शन 126 का स्कोप काफी वाइड है। पहला, जैसा आप देख सकते हैं, सिविल प्रोसीडिंग्स, यहां पर सूट के पार्टीज और उनके स्पाउसेस सभी गवाही दे सकते हैं।
और दूसरा क्रिमिनल प्रोसीडिंग्स, जहां अक्यूज्ड का स्पाउस एक कॉम्पिटेंट विटनेस माना जाएगा। सिंपल।
थ्योरी तो ठीक है, लेकिन इसको असल में समझाने के लिए एक प्रैक्टिकल एग्जाम्पल से बेहतर कुछ नहीं। चलिए एक कॉमन सा कोर्ट सिनेरियो लेते हैं जिससे ये कॉन्सेप्ट बिल्कुल क्रिस्टल क्लियर हो जाएगा।
ओके, सो लेट्स इमेजिन अ सिनेरियो। मान लीजिए ए पर चोरी का इल्जाम है। अब प्रोसिक्यूशन उनकी वाइफ डब्ल्यू को विटनेस बनाकर बुलाती है, क्योंकि डब्ल्यू ने ए को चोरी का सामान घर में छुपाते हुए देखा था। डिफेंस लॉयर ऑफ कोर्स ऑब्जेक्ट करता है। तो सवाल यह है, क्या डब्ल्यू एक कॉम्पिटेंट विटनेस है? द आंसर इज अ क्लियर येस। सेक्शन 126 के अंडर डब्ल्यू पूरी तरह से कॉम्पिटेंट है और कोर्ट उसकी टेस्टिमनी को कंसिडर करेगा।
और इस प्रिंसिपल को सीमेंट करने वाला एक बहुत ही इंपॉर्टेंट लैंडमार्क केस है राम भरोसे वर्सेस स्टेट ऑफ यूपी। इस जजमेंट में सुप्रीम कोर्ट ने यह स्पष्ट कर दिया था कि क्रिमिनल केसेस में एक वाइफ अपने हस्बैंड के खिलाफ एक कॉम्पिटेंट विटनेस है और उसकी टेस्टिमनी पर बिल्कुल भरोसा किया जा सकता है। बट वेट अ मिनट, यहां एक बहुत ही इंपॉर्टेंट सवाल उठता है। क्या कॉम्पिटेंट होने का मतलब यह है कि स्पाउस को हर वो कॉन्फिडेंशियल बात बतानी पड़ेगी जो उनके बीच मैरिज के दौरान शेयर हुई हो? दिस इज अ परफेक्ट सेगवे इनटू आवर नेक्स्ट कॉन्सेप्ट। And this, right here, is probably one of the most important things you need to remember for your exams. Competence, जो हमने सेक्शन 126 में पढ़ा, versus privilege, जो सेक्शन 122 में है। इसको एक सिंपल एनालॉजी से समझिए। सेक्शन 126 यानी कॉम्पिटेंस एक तरह से कोर्ट के विटनेस बॉक्स में आने का एंट्री पास है। ये कहता है कि हाँ, आप बोलने के लिए एलिजिबल हैं। लेकिन सेक्शन 122 यानी प्रिविलेज एक राइट टू रिमेन साइलेंट की तरह है, लेकिन सिर्फ कुछ स्पेसिफिक कॉन्फिडेंशियल बातों के लिए। ये विटनेस को कुछ प्राइवेट बातें ना बोलने का हक देता है। तो आपके पास एंट्री पास यानी कॉम्पिटेंस तो है, लेकिन क्या बोलना है और क्या नहीं, उस पर कुछ रिस्ट्रिक्शंस यानी प्रिविलेज हैं। इस डिफरेंस को हमेशा याद रखें। ओह, एंड वन मोर थिंग टू नोट, सेक्शन 126 एक प्रोसीजरल रूल है। इसका काम है कोर्ट में एविडेंस से जुड़ी प्रोसीजर बताना। ये कोई ऑफेंस डिफाइन नहीं करता और ना ही कोई पनिशमेंट प्रिस्क्राइब करता है। इट्स प्योरली प्रोसीजरल। इस सेक्शन के पीछे एक बहुत ही फंडामेंटल लीगल प्रिंसिपल काम कर रहा है, ऑडी ऑल्ट्रम पार्टेम। इसका मतलब है दूसरे पक्ष को भी सुनो। जब स्पाउसेस को गवाही देने की परमिशन दी जाती है, तो कोर्ट ये इंश्योर करता है कि सच तक पहुंचने के लिए हर तरफ से रेलेवेंट एविडेंस को सुना जाए।
सो द नेक्स्ट लॉजिकल क्वेश्चन इज, कोर्ट एक स्पाउस की टेस्टिमनी को ट्रीट कैसे करता है? देखिए, टेस्टिमनी पूरी तरह से एडमिसिबल है, इसमें कोई डाउट नहीं। लेकिन कोर्ट उसे थोड़ी सावधानी से विथ कॉशन एग्जामिन करता है, क्योंकि एक पोटेंशियल बायस का चांस हमेशा रहता है। बट, एंड दिस इज इंपॉर्टेंट, टेस्टिमनी को सिर्फ इसलिए रिजेक्ट नहीं किया जा सकता क्योंकि विटनेस स्पाउस है।
अब बात करते हैं एग्जाम पॉइंट ऑफ व्यू से। जुडिशरी या एपीओ एग्जाम्स में इस सेक्शन से आखिर किस तरह के क्वेश्चंस बन सकते हैं, चलिए देखते हैं।
प्रीलिम्स में आपसे डायरेक्ट सेक्शन नंबर पूछा जा सकता है, या फिर एक प्रॉब्लम बेस्ड क्वेश्चन दे सकते हैं, जस्ट लाइक द एग्जाम्पल वी डिस्कस्ड। मेंस इंटरव्यू में आपसे कॉम्पिटेंसी ऑफ स्पाउसेस पर एक शॉर्ट नोट लिखने को कहा जा सकता है, या फिर द बिग वन, सेक्शन 126 और सेक्शन 122 के बीच का डिफरेंस, जो हमने डिटेल में डिस्कस किया है।
ऑलराइट, लेट्स डू अ क्विक रिवीजन। 4 मुख्य बातें याद रखिएगा। फर्स्ट, सेक्शन 126। सेकंड, द कोर कॉन्सेप्ट, स्पाउसेस आर कॉम्पिटेंट विटनेसेस। थर्ड, ये सिविल और क्रिमिनल दोनों प्रोसीडिंग्स पर अप्लाई होता है। एंड फोर्थ, कॉम्पिटेंसी और प्रिविलेज कम्युनिकेशन 2 अलग अलग कॉन्सेप्ट्स हैं। एग्जाम के लिए ये सेक्शन बहुत बहुत इंपॉर्टेंट है।
तो दोस्तों, ये था हमारा डिटेल्ड ब्रेकडाउन ऑफ सेक्शन 126। ऐसे ही और जुडिशरी, एपीओ और लॉ एग्जाम फोकस्ड लीगल कंटेंट के लिए गंगा एजुकेशन के साथ जुड़े रहिए।
So, let's start with the big question this section really tackles. Can a judge, the person who presides over the entire court, actually be called to step down from the bench and into the witness box? It's a pretty compelling thought, isn't it? And you'll see the law has a very specific, very nuanced way of handling it. So, let's find out exactly how. Now, in this explainer, we're going to take a really structured journey through Section 127. We'll kick things off with an introduction. Then we'll decode the exact language of the BEAR Act itself. After that, we'll explore the critical difference between when a judge is protected and when they can be examined. We'll also look at some key judgments, understand the real purpose behind this section, and finally, we'll zoom in on what you absolutely need to know for your exams.
Okay, let's get right into it. Section 127 of the Indian Evidence Act 1872 is often called the shield of the judiciary. And trust me, it's for a very, very good reason.
So you might be asking, why is this section so important, especially for your judiciary and APO exams? Well, it's because it provides a fundamental, almost sacred protection to judges and magistrates. This allows them to do their jobs independently, without being afraid of being randomly questioned about their decisions. This is absolutely essential for maintaining the dignity and the overall integrity of our entire judicial system.
Right, now let's get into the nitty-gritty. We're going to examine the exact wording of the law itself. As you know, understanding the bare act is always the first and most important step to mastering any legal section.
The key line here says that no judge or magistrate can be compelled, and that's the magic word, compelled to answer questions about his own conduct in court as a judicial officer. So in simple terms, this means you can't force a judge to get on the stand and justify their judicial actions. But, and this is a big but, there's a crucial exception. To really get this, let's break it down into keywords. First, who does it apply to? Only judges and magistrates. What's the protection? They cannot be forced to answer questions about their official conduct in court. Now, what's the exception? Well, they can be questioned about other things they witnessed happening in their presence. And here's the clincher, the requirement. This protection, this shield, can only be lowered with a special order from a superior court. And this brings us right to the heart of the matter. It's this delicate balance, this fine line between what a judge is protected from and what they can be questioned on. Understanding this distinction is absolutely key to understanding the whole section. Just look at how this slide lays it out so clearly. On the one hand, a judge is shielded. They can't be compelled to talk about their judicial conduct, like why they wrote a judgment a certain way. But on the other hand, they are not shielded from testifying about facts they simply observed, just like any other person. So, for example, if an assault happens right there in the courtroom, the judge is a witness to that event, and they can be questioned about it.
So how does this actually play out in a real-world scenario? Well, imagine a party wants to question a judge about their judicial conduct. The moment that happens, the shield of Section 127 automatically kicks in. Now, that shield can only be removed through a very formal process, a special order from a superior court. This acts as a really important check and balance in the system.
And this slide gives us a perfect practical example. Let's look at illustration A directly from the Act. Say an accused person claims that the magistrate didn't record their statement properly. Can they just call the magistrate to the stand and question them? The answer is a clear no, not without that special order from a superior court, because the question is directly about their judicial conduct. Now let's contrast that with illustration C. This is a wild one. An accused person literally tries to murder a witness right there in the courtroom, and the judge sees the whole thing happen. Can the judge be examined about what they saw? Oh, absolutely yes. See the difference? This has nothing to do with their judicial conduct. It's about a factual event they personally witnessed.
Okay, to really cement our understanding, let's look at some important case laws. These judgments are fantastic because they show us how courts have actually interpreted and applied this principle over the years.
A foundational case you just have to know is R versus Sussex Justices. In this landmark judgment, the court gave us that famous principle. Justice must not only be done, but it must also be seen to be done. This idea is the very bedrock of judicial integrity, and Section 127 protects it fiercely by preventing situations that could make a judge appear partial.
And that very line has become a powerful legal maxim. What it really means is that the whole process of justice has to be so transparent and fair that it builds public confidence. Section 127 directly supports this by making sure a judge isn't put in an awkward position where their impartiality could be questioned in open court.
And it doesn't stop there. Other key cases, like Anil Kumar Neodia, have strongly emphasized the independence of the judiciary. And then you have cases like K. Veeraswamy, which explored that tricky balance between protecting judges and also holding them accountable. All of these cases just reinforce the core ideas behind Section 127.
So after all this discussion, we kind of come back to the most fundamental question. What's the ultimate purpose of this section? Why does this rule even exist in our law books? Well, there are really four main goals here. First, and most importantly, is to protect judicial independence. Second, it's about maintaining the dignity of the court itself by not forcing judges to publicly defend their judgments. Third, it prevents harassment of judicial officers. And finally, it actually helps ensure a fair trial by balancing that protection with the need to allow a judge's testimony when it's absolutely crucial for justice.
All right, let's shift gears now and focus specifically on what you need to remember for your exams. This is the practical, need-to-know part of our explainer. So here's your exam tip. For your judiciary and APO prelims, you can definitely expect a direct, section-based question. For the mains, you need to be ready for two things, either a short note on Section 127 or a problem-based question, which will almost certainly be based on one of the illustrations we just talked about.
And here's your super quick revision guide. Just remember 3 key things. First, the section number 127 of the Indian Evidence Act. Second, the core concept. Judges are competent witnesses, but they are not compellable when it comes to their judicial conduct. And third, the all-important exception. This protection can be lifted, but only by a superior court's order. Its importance for your exams is definitely high.
And that's a wrap on Section 127. As you can see, it strikes a really careful and intelligent balance between judicial protection and the delivery of justice, making sure a judge is shielded but never above accountability. For more legal content focused on judiciary, ABO, and other law exams, please stay connected with Ganga Education.
We're talking about Section 128, which deals with marital communications. Now, for anyone gearing up for the judiciary and APO exams, getting a solid grip on this section is, well, it's absolutely non-negotiable.
So, let's kick things off with a question that comes up all the time, both in exams and in real-world legal situations. Can a wife actually be forced to testify against her husband in a court of law? The answer to that question comes right back to the very section we're about to unpack, and it tells us a whole lot about how the law views the sanctity of marriage.
You know, the entire spirit of Section 128 can be summed up by this simple idea. The section basically gives us a powerful legal shield for any and all conversations that happen within a marriage. You can almost think of it as a legally created zone of trust, a completely private space protected by the law, all to preserve the marital bond.
Now, you might be wondering, why does the law do this? Well, it's not some random rule. It's built on a very strong foundation of public policy. You see, the thinking is that for a marriage to really work, for it to be strong, spouses need to be able to talk freely and honestly, without that chilling fear that their private words could somehow be used against them in court one day.
Okay, so with that background in mind, let's get into the nitty-gritty. We're going to break down the key ingredients of the actual legal text of Section 128. And as we do, you'll see that every single word in there is chosen very carefully and has some serious weight. The first, and I mean the absolute first requirement, is a valid marriage. This is non-negotiable. This legal protection, this special privilege, it only kicks in for communications that happen between people who are legally married. If there's no valid marriage, well then this whole protection just doesn't apply. Simple as that.
The second critical piece of the puzzle is all about timing. The protection is strictly, and I mean strictly, for communications made during the marriage. So any chats, any statements, or even letters that were exchanged before the wedding day or after a legal divorce, none of that is covered by the shield of Section 128.
And the third key element is the prohibition itself. Disclosure prohibited means a spouse can't be forced or compelled to reveal what was said. But here's the really interesting part. They also aren't permitted to just volunteer that information without consent. So you see, it works both ways. It's a shield that protects them, but it's also a restriction that binds them.
So if we map it out, the structure here is incredibly logical. Step 1, a communication happens between a husband and wife. Step 2, the general rule immediately applies. That conversation is privileged, it's protected. But, and this is a big but, it's not an absolute rule. That brings us to Step 3, the specific exceptions where, yes, disclosure is actually allowed.
And this right here is the central balancing act of the entire section. On one hand, you've got this very powerful general rule that fiercely protects that zone of trust. But on the other hand, the law knows that justice has to be served, so it creates these very specific, very narrow legal gateways, the exceptions, where that privilege has to be set aside. So what exactly are these gateways? Well, first up, we have consent. If the spouse who actually made the statement agrees to let it be disclosed, the privilege is waived. Second, in suits between spouses. So if the husband and wife are suing each other in a civil case, like a divorce or a maintenance hearing, the protection doesn't apply. And third, in the serious case of a crime against the spouse, where one is on trial for a crime against the other.
All right, let's make this real. Let's use a practical exam-style situation. Imagine a husband confesses to his wife in the privacy of their home that he has committed a massive financial fraud. And this conversation,
It happened while they were very much married.
Okay, so now the police get involved. They start investigating this fraud, and they find out that the wife knows what her husband said. So here's the question for you. Can she be forced to get on that witness stand and testify about her husband's confession? Think about it for a second. How does the rule apply here?
And the answer is a clear, definitive no. That confession is a privileged marital communication, plain and simple, under Section 128. She cannot be compelled to testify about it, and just as importantly, she can't even choose to testify about it on her own, unless her husband gives his express consent. In this scenario, that legal shield is rock solid.
Now, this very principle was beautifully laid out by the Supreme Court in the landmark case of M.C. Verghese versus T.J. Ponin. The court made it crystal clear that even things like letters exchanged between a husband and wife fall under the definition of communication. And because they do, they are privileged. They simply can't be used as evidence without consent. It's a great case that shows just how wide the law casts this net of communication.
You know, to really understand the why behind this whole public policy, it helps to look at a related legal maxim. And that maxim is interest rei publicae ut sit finis litium.
So what does that mean in simple English? It means it is in the interest of the state that there should be an end to litigation. The policy behind Section 128 is kind of like a cousin to this idea. The thinking is that it's in the state's best interest to protect and strengthen the institution of marriage, to stop it from becoming a constant source of legal battles.
Now, here's a super important point, and it's a favorite for exam questions. This privilege, it's permanent. It attaches to the communication itself, forever. What that means is, even if the couple gets divorced, or even if one of the spouses dies, the communications that happen during the marriage stay protected. That protection doesn't just disappear.
And now, let's talk strategy. Here's a specific tip for your exams. For your prelims, you can pretty much expect direct questions that focus on those 3 exceptions we talked about. But for your mains exam, you need to be ready for problem-based questions. They'll likely give you a scenario to test if you understand the subtle difference between a protected communication and a non-protected act that a spouse might have just observed.
All right, time for a super quick revision. Let's lock in the 3 most important things to remember. First, we're talking about Section 128 of the Indian Evidence Act. Second, the core idea is that marital communications are privileged. And third, never forget the key exceptions. Consent, suits between spouses, and a crime by one against the other. Got it?
At the end of the day, Section 128 is a really fascinating bit of law. It's all about trying to strike this incredibly delicate balance, right? A balance between protecting that very private zone of trust in a marriage and the bigger public interest in making sure justice is delivered. So the final thought I want to leave you with is this. In today's world, how well do you really think the law manages to achieve that balance? For more deep dives into legal concepts that are crucial for your judiciary, APO, and other law exams, make sure you stay connected with us right here at Ganga Education.
Hello, everyone, and welcome to Ganga Education. Today, we're diving into a really important section of... I'm talking about Section 129, which covers evidence as to affairs of state. Now, if you're preparing for your judiciary and APO exams, you'll know that this section is a must-know. It's absolutely crucial. So let's kick things off with a big question, something to really get you thinking. Can a court actually force the government to reveal its most secret, most sensitive national security documents? I mean, really think about that. This question, it's the very core of what Section 129 is all about, and it highlights this really delicate balancing act. All right, so in today's explainer, we're going to break down Section 129 piece by piece. The whole thing is built on a legal principle called state privilege. And what that really means, in simple terms, is the idea of protecting the government's important secrets, all in the name of the public's best interest. So this section deals with what's called the privilege relating to state affairs. And to put it simply, its main job is to stop confidential government records from being revealed in a courtroom. You can see it's trying to walk this tightrope, right? It's balancing the need for justice in our courts with the absolute necessity of protecting our national interest and security. Okay, let's get into the nitty-gritty. We're going to deconstruct this provision now, breaking down the actual legal text into simple parts that are easy to grasp. So here's what the Bear Act says, and I'll read it out. No one shall be permitted to give any evidence derived from unpublished official records relating to any affairs of state except with the permission of the officer at the head of the department concerned. The meaning is pretty straightforward, right? Basically, you can't use evidence from secret government files in court unless the big boss of that department, the head of department or HOD, says it's okay. Now, the first key phrase we need to lock down is unpublished official records. This is so important. For a document to get this special protection, it has to pass a two-part test. First, it's got to be an official government record, and second, it has to be unpublished, meaning it hasn't been shared with the general public. And the second key phrase to understand is affairs of state. And let me tell you, this is a really broad term. We're talking about things like national security, our diplomatic ties with other nations, top-level cabinet meeting notes, the really sensitive government stuff. It's the kind of information that, if it got out, could genuinely harm the country's security or how it's run. So to quickly recap the essentials here, we've got three main ingredients. 1. Unpublished official records. 2. It has to relate to the affairs of state. And 3. You need permission from the head of the department. And remember, it's completely up to the HOD to decide whether to give or deny that permission, and their decision is supposed to be all about what's best for the public. Okay, so we've got the theory down, but how does this actually play out in a real legal situation? Let's talk about the legal tests that courts use and look at some practical examples you might see. So imagine a piece of evidence like this pops up in court. The court has a clear process to follow. Step 1, the judge checks if it's an unpublished official record. If yes, they move to Step 2, does it relate to affairs of state? If the answer is yes again, then Step 3 kicks in. The permission of the department's HOD is now required. It's that HOD who then has to make the final call, based on what's in the public's best interest. Let's get practical with some exam-focused examples. Think about this. One side in a court case demands to see the Army's secret strategy papers. Well, Section 129 would step in and say, nope, not so fast. Those documents are off limits unless the head of the Defense Ministry gives the green light. And this isn't just for military stuff. The exact same rule applies to confidential cabinet meeting notes or internal memos between government departments. Of course, like any law, Section 129 hasn't just existed in a vacuum. It's been interpreted, shaped, and clarified over the years by some major court cases and core legal principles. So let's dive into those now. You can actually see how the court's thinking on this has changed over time. If you look at an early case, State of Punjab versus Sodhi Sukhdev Singh, the court said yes, state privilege exists, but it also stressed that judges need to look at these claims carefully. Then fast forward to the really big one, SP Gupta versus Union of India. Here, the Supreme Court really put the brakes on the idea of an absolute privilege. They carved out a much clearer balance between the government's need for secrets and the public's right to know. There's a classic legal maxim that really gets to the heart of this section. It's salus populi suprema lex. It means the welfare of the people is the supreme law. And that's the core justification, right? The idea is that sometimes keeping state secrets safe is the best way to protect the overall welfare of the people. So this all leads to a really important question, doesn't it? Who makes sure the government doesn't just use this power to hide things it shouldn't? Well, that's where the courts step in, and their role here is absolutely vital. Let's explore how they do this balancing act. Think of the court as a gatekeeper. Its job is to make sure that Section 129 isn't just used as a convenient shield for the government to hide mistakes or wrongdoing. So the court has the power to look closely at the government's claim of privilege. They have to do this tough job of weighing two things: the public's interest in seeing justice done versus the public's interest in keeping that information secret. So what's the bottom line? It's actually very simple. If the HOD gives the okay, the evidence is in, it's admissible in court. But if the HOD says no and withholds permission, that's it. The evidence is privileged and it cannot be used in the case. It's inadmissible. Okay, let's bring this all back to what matters most for you: the exams. How do you apply all this knowledge when you're sitting for your judiciary and APO papers? Here's a key exam tip for you. For your prelims, be prepared for direct questions. They might ask for the section number itself or about the core principle of state privilege. But for the mains exam, you should expect a problem-based question. They'll give you a scenario, a set of facts, and you'll have to apply Section 129 to figure out the answer. All right, let's do a super quick revision. If you're cramming last minute, just lock these three things in your mind. 1, the section number is 129 of the Indian Evidence Act. 2, the core concept is protecting the government's confidential info. And 3, the key principle is that big balancing act between national security and the needs of justice. And that wraps up our deep dive into Section 129. For more legal breakdowns like this, all focused on helping you ace your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. That, let's be honest, often confuses students in exams. I'm talking about Section 130, which deals with official communications. Now, if you're gearing up for your judiciary or APO exams, this explainer is absolutely crucial for you. So let's get right into it. So, how are we going to master Section 130? Well, we have a clear roadmap. First, we'll get a solid grip on the basic rule. Then, we're going to deconstruct it, break it down into its core components. After that, we'll see it in action with some real-world examples, compare it to the very similar Section 129, understand its true legal nature, and finally, we'll zero in on exactly what you need to know for your exams. Okay, let's start at the very beginning, with a fundamental rule. The whole idea behind Section 130 is to protect confidential official communications. It's actually quite simple when you think about it. The goal is to let government officials do their work freely and honestly, without the fear that their confidential discussions might be exposed, all in the larger public interest. What you're seeing here is the text straight from the BEAR Act. But what does it mean in plain language? Well, सीधे शब्दों में, इसका मतलब है कि किसी भी पब्लिक ऑफिसर को मजबूर नहीं किया जा सकता कि वो ऐसी कोई कम्युनिकेशन डिस्क्लोज करें जो उन्हें ऑफिशियल कॉन्फिडेंस में दी गई हो, अगर उन्हें लगता है कि उसको डिस्क्लोज करने से पब्लिक इंटरेस्ट को नुकसान होगा. Now that we have the basic rule down, let's really get into the nitty-gritty. To truly understand how Section 130 works, we need to pull it apart and look at its essential ingredients. This will make everything crystal clear. So, as you can see, there are really 4 key elements at play here. First up, the public officer. This is any government official acting in their official role. Second, official communication. We're talking about information that's shared both confidentially and in an official context. Third, and this is the big one, the public interest test. This is the check to see if revealing the information would actually cause harm. And finally, the discretion of the officer. The power to make that call rests with the officer themselves. And here's where it all comes together logically. Think of it as a step-by-step process. First, a public officer gets a communication. The key is it has to be in official confidence. Then, that officer applies the public interest test. And based on that assessment, they use their discretion to either share the information or keep it confidential. This is the exact sequence a court looks at. Okay, theory is great, but let's get practical. How does this actually play out in a real-world scenario or a courtroom? Let's dive into some practical examples and a landmark case to really see Section 130 in action. Here's a classic example for you. Let's paint a picture. Imagine a police officer gets a top-secret intelligence report about a potential terrorist threat in the city. Now, under Section 130, that officer cannot be forced to reveal the contents of that report in court. Why? Because doing so could seriously jeopardize public safety and compromise national security. You simply cannot talk about Section 13 without bringing up this landmark case, State of Uttar Pradesh versus Rajnarayan. This case was a game changer, and it fundamentally shaped how our courts interpret that crucial public interest clause. So the central question before the court was this: is the state's power to hide information absolute? Can they just refuse to disclose anything they want? The court's answer was a clear and resounding no. It held that public interest is a two-way street. It doesn't always mean secrecy. In fact, sometimes the public interest actually demands disclosure. This judgment created that vital balance between government secrecy and a citizen's right to know. And this entire judicial philosophy is beautifully captured by a classic legal maxim, salus populi suprema lex. It simply means the welfare of the people is the supreme law. This very principle is the bedrock of the public interest test we see in Section 130. Okay, let's tackle a question that I know confuses a lot of law students. What's the real difference between Section 129 and Section 130? They both talk about privilege, but they are definitely not the same. Let's clear this up once and for all. So have a look at this. The crucial difference really boils down to a few things. On one hand, you have Section 129. It's much broader, covering affairs of state, like official records and documents, and the privilege has to be claimed by the head of the department. But on the other hand, Section 130 is narrower. It applies specifically to communications, and the privilege is claimed by the individual public officer who actually received it. All right, let's pause for a second and talk about something really important for your conceptual clarity. What kind of law is this exactly? What is the legal nature of Section 130? Now, this is something you absolutely have to lock in for your exams. Section 130 is an evidentiary privilege. It is not a penal offense. This means it's not about crime and punishment. It is a rule about evidence, what can and cannot be presented in court. So remember, There is absolutely no punishment prescribed under this section. Okay, let's switch gears and focus squarely on your exams. What do you really need to know to ace any question that comes your way on Section 13 in your judiciary or APO papers? Let's break it down. For your prelims, be ready for direct questions on the section number. It's a common one. For the mains, you're more likely to get problem-based questions that really test your understanding of the public interest concept. And a short note on the difference between Sections 129 and Section 130 is a high-probability question. Finally, in the interview, be prepared to discuss that delicate balance between government secrecy and public transparency. All right, time for a super quick revision. If you remember nothing else from this discussion, remember these three things. First, the section number, 130. Second, the core concept. It's a privilege for official communications based on public interest. And third, the key principle from case law, an officer's discretion is not final, it can be reviewed by a court. So, I want to leave you with a final thought to chew on. How do our courts actually strike that perfect balance between the government's genuine need for secrecy and a citizen's fundamental right to know, all in the service of justice? That's really the central challenge of this entire section. For more detailed explainers just like this one on all the crucial topics for your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. So, what's on the agenda for today's explainer? We're breaking down Section 131. We'll start with the basics, then get into what this privilege is all about. We'll also see how it works in a real courtroom, understand the reason behind this rule, and finally, focus on some key points for your exams. Let's get right into it. All right, first up, let's talk about the basics of Section 131. This section establishes a very, very important legal privilege, and it's all about serving the public interest. So here it is, Section 131 of the Indian Evidence Act, 1872. Now, this section is all about information related to the commission of offenses, and let me tell you, it's particularly important for anyone preparing for the judiciary and APO exams. Okay. Let's look at the actual text from the Act. It says, and I'm quoting here, that no magistrate or police officer can be compelled to reveal where they got their information about a crime. And you'll see the same protection is given to revenue officers for tax-related offenses. So, in simple terms, what does this all mean? It means a court cannot force these officers to get on the stand and name their informants. It's as simple as that. Now that we have the basic idea, let's really break this section down into its essential parts. This will help us understand its structure much more clearly. You see, this section really has three important elements. First, who does it apply to? Well, this privilege isn't for everyone. It's specifically for magistrates, police officers, and revenue officers. Second, what information is it about? The protection covers any tip or info about the commission of an offense. And third, what is the protection granted? This is the real heart of the rule. These officers cannot be forced to disclose the source of their information or even when they got that tip. This little flowchart here really helps illustrate how it all works. So it starts with a specific public officer getting some information about a crime. Later, when that officer is called to testify in court, boom, Section 131 kicks in, giving them the privilege to protect their source. Okay, theory is one thing, but how does this actually play out in a real courtroom? Let's look at how this section works in practice with some examples and a very important landmark case. Let's imagine a scenario. Picture a police officer who gets a secret tip from an informer. The tip is about a major drug trafficking operation happening at a specific warehouse. Now, when this case goes to court, the police officer can absolutely testify about the facts of the raid, the drugs they found, the arrests they made. But, and this is the key, they cannot be forced to say who gave them that tip. They can't even be forced to say exactly when they received it. And the reason for this is fundamental. It's all about protecting that informer from any kind of backlash from the criminals. This whole principle is really highlighted in the landmark case of State of Punjab versus Sodhi Sukhdev Singh. In this major judgment, the Supreme Court talked all about the privilege of official communications and documents, basically reaffirming just how important it is to protect the public interest above everything else. So this brings us to a really important question. Why? Why do we even have this section? What's the legal philosophy and the public policy driving it? Well, you can understand the entire principle through a famous legal maxim. Salus populi suprema lex. It sounds fancy, but it just means the welfare of the people is the supreme law. See, by protecting informers and their sources, the law makes sure law enforcement can be effective, and that, ultimately, serves the welfare of all of us. This section actually has several critical goals. First and foremost, it shields informers from harm. Second, it gives regular citizens the confidence to report crimes without being afraid. Third, it helps maintain the secrecy and therefore the effectiveness of police investigations. And finally, it also helps protect our public revenue system from fraud. It's a really powerful tool. All right, let's shift gears and get to the part that many of you are waiting for, the exam focus. These points are absolutely critical for all the judiciary and APO aspirants out there. So, Section 131 creates what we call a rule of privileged communication. The direct consequence is that the court simply cannot compel an officer to disclose their source or the timing. But here's the crucial point to remember. This doesn't mean the evidence itself gets thrown out. Not at all. It's only the source of that evidence that is protected. And here is a very important update for your exams. This provision that we've been discussing was, of course, in Section 131 of the Indian Evidence Act. Now, with the new laws, it's been moved. You'll now find it in Section 134 of the new Bharatiya Sakshya Adhiniyam 2023. But remember, while the number has changed, the core principle is exactly the same. Okay. Here's a pro tip for your judiciary and APO exams. For the prelims, be ready for a direct question asking which officers are covered by this section. It's a classic one. For the mains, there's a very high chance you'll get a problem-based question involving an informant's tip to an officer, so be prepared for that scenario. All right, let's do a super quick revision. Just remember these three things. First, Section 131. Second, its core concept is all about protecting the source of information about a crime. And third, its exam importance is very, very high because this entire rule is designed to protect the broader public interest. And that wraps up our deep dive into Section 131. For more legal content that's laser-focused on judiciary, APO, and other law exams, make sure you stay connected with Ganga Education.
Today, we're going to dive deep into a real cornerstone of legal ethics and evidence law. We're talking about Section 132, which covers advocate-client privilege.
So here's our roadmap for this explainer. We'll start with the basics of what the section is all about. Then we'll break down the core rule itself. After that, we'll get into the really crucial exceptions, look at some landmark cases, and finally, we'll wrap up with a sharp focus on exam tips to make sure you're fully prepared. Let's get started.
All right, let's jump right into our first part. What exactly is Section 132? You know, this is an absolutely vital topic, one that you'll definitely see in your judiciary and AMPO exams.
Okay, so Section 132 of the Indian Evidence Act 1872. This section deals with something we call professional communications. At its very heart, it's the fundamental legal rule that creates a confidential shield around the conversations between a lawyer and their client.
Now, this core principle, it's foundational to our entire justice system. Why is it so important? Well, this protection is absolutely essential. It allows a client to tell their advocate everything, all the facts, honestly and without any fear. This full and frank disclosure is what lets the advocate give the best possible legal advice, making sure that justice is properly served.
So, we understand the why behind the rule. Now let's break down the how. We're going to look at the exact language of the BEAR Act to really get a grip on all of its components.
The key really lies in this single line from the Act. So, to put it in simple terms, it means that no advocate can ever be forced to share any professional information given by their client, unless, and this is the important part, unless the client gives their express consent, that is, clear and direct permission.
You know, for this privilege to apply, 4 key elements have to be there. First, you need that professional advocate-client relationship. Second, the whole point of the communication must be for getting or giving legal advice. Third, this confidentiality can only be broken with the client's express consent. And finally, remember this is a continuing obligation. It doesn't just vanish once the case is over.
So how does a court figure out if a communication is privileged? Well, it usually applies a kind of logical test. First, they ask, was there an advocate-client relationship? Check. Second, was the communication for professional reasons? Check. And the third and most crucial question, has the client given consent to disclose it? If the answer to that last one is no, then that communication is absolutely protected.
And now we've reached what is probably the most critical part of this section, especially for your exams. The situations where this shield of privilege, well, it just doesn't apply.
The key thing to remember is this simple but really powerful distinction. If a client confesses to a crime that was committed in the past to get help with a legal defense, that conversation is protected. But if a client comes asking for advice on how to commit a future crime or fraud, that conversation is not protected at all. You see, the law protects honest legal consultation, not criminal collaboration. It's a very clear line.
Now, the legal basis for these exceptions comes directly from the provisos in Section 132. The first one clearly says that any communication made to help an illegal purpose is not protected. And the second one says that if an advocate, during their work, observes any fact that shows a crime or fraud has been committed, that observation isn't privileged either.
Okay, let's use a practical example, the kind you might see in an exam. Imagine a client asks his advocate for advice on how to successfully use a forged document in a property case. Is that conversation protected? The answer is a definite no. It falls right into that illegal purpose exception we just talked about.
Now, let's shift gears a bit and see how the courts have actually interpreted and strengthened these principles through some very important case laws and well-established legal maxims.
The landmark English case, R.V. Cox and Railton, is the one that really established what we now call the crime-fraud exception. The court's ruling was clear. Any communication made for a criminal or fraudulent purpose is simply not privileged. And this fundamental principle is followed in Indian law too.
You know, this whole principle can also be understood through a legal maxim. Nemo tenetur se ipsum accusare. What does it mean? No one is bound to incriminate himself. This maxim perfectly supports the general rule of privilege because it allows a client to speak freely with their advocate, which, as we've said, is essential for preparing a proper defense.
All right, in this final section, let's pull everything we've learned together and focus specifically on what you need to remember for your exams.
It's really important to get that this isn't some new idea that the Act just invented. Section 132 simply codifies, or in other words, it formally writes into law, the long-standing common law principle of advocate-client privilege that's been a part of our legal tradition for centuries.
So what happens if a lawyer actually breaches this duty? Well, Section 132 itself doesn't hand out a jail term or criminal punishment. However, and this is a big however, a breach is seen as a very serious case of professional misconduct. The advocate can face disciplinary action under the Advocates Act, which can have really severe consequences for their career.
Now, let's talk exam strategy. For your prelims, you should definitely expect direct questions on the section number, its core concept, and especially the exceptions. For your mains, be prepared to write a short note on advocate-client privilege and get ready for those problem-based questions where you'll have to apply your knowledge of the exceptions to a specific scenario.
So, for a super quick revision, just remember these three key things. 1. The section number is 132. 2. The core concept is the protection of advocate-client communication. And most importantly, 3. The main exception is that this privilege ends right where illegality begins. Got it?
For more judiciary, APO, and other law exam-focused legal content, please stay connected with us here at Ganga Education.
सेक्शन 133 जुडिशरी और एपीओ एग्जाम्स के पर्सपेक्टिव से ये सेक्शन काफ़ी इम्पॉर्टेंट है क्योंकि ये एडवोकेट क्लाइंट प्रिविलेज के वेवर जैसे कॉम्प्लेक्स टॉपिक से डील करता है। सो लेट्स गेट स्टार्टेड। आज के इस एक्सप्लेनर में हम इन 6 की एरियाज को कवर करेंगे। हम शुरू करेंगे कोर प्रिंसिपल से, फिर उसकी लीगल एसेंशियल्स को डीकोड करेंगे, उसके बाद हम कुछ प्रैक्टिकल एग्जांपल्स देखेंगे, इंपॉर्टेंट जजमेंट समझेंगे, सेक्शन 132 के साथ इसका रिलेशन एक्सप्लोर करेंगे और लास्ट में एग्जाम फोकस और एक क्विक रिविजन के साथ इसको रैप अप करेंगे। चलिए एक सिचुएशन इमेजिन करते हैं। मान लीजिए एक क्लाइंट अपनी मर्जी से विटनेस बॉक्स में आकर गवाही देता है, तो क्या उसके इस एक एक्ट से उसके और उसके लॉयर के बीच की कॉन्फिडेंशियलिटी ऑटोमेटिकली टूट जाती है? क्या उनका प्रिविलेज वैसे ही वेव हो जाता है? इसी सवाल का जवाब देता है सेक्शन 133 और उस सवाल का जवाब है अ फर्म नो। और इस नो के पीछे जो लीगल फाउंडेशन है वो हमें सेक्शन 133 में मिलता है। लेट्स ब्रेक डाउन इट्स कोर प्रिंसिपल। द फंडामेंटल आइडिया इज एक्चुअली क्वाइट सिंपल। सिर्फ विटनेस बॉक्स में एंटर करने से या गवाही देने से एक क्लाइंट का एडवोकेट क्लाइंट प्रिविलेज खत्म नहीं हो जाता। वो जो कॉन्फिडेंशियलिटी की शील्ड है वो अपनी जगह पर मजबूती से बनी रहती है। अब जरा बेयर एक्ट की लैंग्वेज देखते हैं। ये कहता है, इफ एनी पार्टी टू अ सूट गिव्स एविडेंस देयरिन एट हिज ओन इंस्टेंस, he shall not be deemed to have consented thereby to such disclosure as is mentioned in section 126। सिंपल शब्दों में इसका मतलब है कि गवाही देने का एक्ट अपने आप में प्रिविलेज्ड इन्फॉर्मेशन को डिस्क्लोज करने की सहमति या कंसेंट नहीं माना जाएगा। इस कॉन्सेप्ट को पूरी तरह से समझने के लिए हमें इस सेक्शन के लीगल एसेंशियल्स को ब्रेक डाउन करना होगा। इन इंडिविजुअल कंपोनेंट्स को समझना ही इसकी एप्लीकेशन को मास्टर करने की की है। इस टेबल में 4 की एलिमेंट्स हैं। फर्स्ट, वॉलंटरी एविडेंस, मतलब क्लाइंट का गवाही देना ऑटोमेटिक वेवर नहीं है। सेकेंड, प्रोटेक्शन कंटिन्यूज, यानी सेक्शन 126 के अंडर जो कॉन्फिडेंशियल कम्युनिकेशन प्रोटेक्टेड है वो प्रोटेक्टेड ही रहेगी। थर्ड, कॉलिंग एडवोकेट, वेवर तभी ट्रिगर होता है जब क्लाइंट अपने एडवोकेट को बुलाए और उनसे प्रिविलेज्ड मैटर्स पर सवाल पूछें। और फोर्थ, एंड दिस इज रियली इंपॉर्टेंट, कोई भी वेवर लिमिटेड वेवर होता है, ये सिर्फ उस स्पेसिफिक क्वेश्चन तक ही सीमित है, जनरल वेवर नहीं है। चलिए इस वेवर के लॉजिक को स्टेप बाय स्टेप ट्रेस करते हैं। सबसे पहले पार्टी गवाही देती है। इस स्टेज पर प्रिविलेज कंटिन्यू करता है। अब वेवर की बात तब तक नहीं आती जब तक तीसरा स्टेप ना हो, इंटेंशनल क्वेश्चनिंग, जहां क्लाइंट जानबूझकर अपने एडवोकेट से किसी प्रिविलेज्ड मैटर के बारे में पूछता है। सिर्फ तब चौथे स्टेप पर उस स्पेसिफिक इंफॉर्मेशन के लिए एक लिमिटेड वेवर होता है। देखिए, थ्योरी एक बात है, लेकिन लॉ तो असल में प्रैक्टिकल एप्लीकेशन से ही समझ में आता है। चलिए कुछ एग्जाम ओरिएंटेड सिनेरियोज देखते हैं ताकि ये कॉन्सेप्ट बिल्कुल क्लियर हो जाए। ये एग्जाम्पल्स डिफरेंस को बिल्कुल साफ कर देते हैं। पहला सिनेरियो, नो वेवर में ए गवाही देता है लेकिन उसकी कॉन्फिडेंशियल बातें प्रोटेक्टेड रहती हैं। दूसरे में पार्शियल वेवर, ए अपने लॉयर से कॉन्ट्रैक्ट पर दी गई एडवाइस के बारे में पूछता है। यहाँ वेवर सिर्फ उस स्पेसिफिक एडवाइस के लिए है। और तीसरे सिनेरियो में ए एडवोकेट को विटनेस के तौर पर बुलाता है लेकिन कोई भी कॉन्फिडेंशियल सवाल नहीं पूछता, इसलिए प्रिविलेज पूरी तरह से इंटैक्ट रहता है। किसी भी लॉ को ठीक से समझने के लिए हमें ये देखना जरूरी है कि जुडिशरी ने उसे कैसे इंटरप्रेट किया है। लैंडमार्क जजमेंट्स और लीगल मैक्सिम्स इस ब्लैक लेटर लॉ को कॉन्टेक्स्ट और अथॉरिटी देते हैं। इस टॉपिक पर सबसे इंपॉर्टेंट केस है MC वर्गेज वर्सेस TJ पॉन्नन। इस केस ने एडवोकेट क्लाइंट कॉन्फिडेंशियलिटी की फंडामेंटल इंपॉर्टेंस को रीएनफोर्स किया, इसलिए ये केस आपके मेंस आंसर्स के लिए काफी वैल्यूबल है। यहाँ 2 और इंपॉर्टेंट केसेस हैं। R वर्सेस डर्बी मैजिस्ट्रेट्स में ये होल्ड किया गया कि लीगल प्रोफेशनल प्रिविलेज एब्सोल्यूट है और उसे सिर्फ क्लाइंट ही वेव कर सकता है। और बर्ड वर्सेस लवलेस एक फाउंडेशनल कॉमन लॉ केस है जिसने लीगल प्रिविलेज के कॉन्सेप्ट को एस्टैब्लिश करने में हेल्प की थी। हम इस प्रिंसिपल को एक लैटिन मैक्सिम से भी समझ सकते हैं, नीमो टेनिटूर से इप्सिम अक्यूजारे। इसका मतलब है किसी को भी खुद को दोषी ठहराने के लिए मजबूर नहीं किया जा सकता। प्रिविलेज्ड कम्युनिकेशन एक तरह से इसी प्रिंसिपल का एक्सटेंशन है जो क्लाइंट को उसकी कॉन्फिडेंशियल लीगल एडवाइस रिवील करने से बचाता है। अब हम एक बहुत ही इंपॉर्टेंट पॉइंट पर आते हैं। सेक्शन 133 को हम अकेले नहीं पढ़ सकते, इसको हमेशा सेक्शन 132 के साथ मिलाकर ही समझना चाहिए। आइए देखते हैं कि ये दोनों कैसे काम करते हैं। ये टेबल इनके रिलेशनशिप को बिल्कुल क्लियर कर देता है। देखिए, एडवोकेट क्लाइंट प्रिविलेज तो सेक्शन 126 में एस्टैब्लिश होता है। फिर आता है सेक्शन 132 जो एक विटनेस को इनक्रिमिनेटिंग क्वेश्चंस का भी जवाब देने के लिए कंपेल करता है लेकिन उसे इम्यूनिटी देता है। तो सेक्शन 133 कहाँ फिट होता है? ये एक सेफगार्ड की तरह काम करता है। ये इंश्योर करता है कि सिर्फ इसलिए कि एक पार्टी विटनेस बन गई और सेक्शन 132 के अंडर आंसर दे रही है, वो गलती से सेक्शन 126 के अंडर मिले अपने प्रिविलेज को वेव ना कर दे। चलिए अब इस एक्सप्लेनर के आखिरी सेगमेंट की तरफ चलते हैं जो आपके एग्जाम प्रेपरेशन के लिए सबसे ज्यादा इंपॉर्टेंट है।
अपने जुडिशरी और APO एग्जाम्स के लिए इन टिप्स को ध्यान में रखें। प्रीलिम्स में सेक्शन नंबर या इसके कोर प्रिंसिपल पर डायरेक्ट क्वेश्चन आ सकता है। मेंस के लिए एक शॉर्ट नोट या प्रॉब्लम बेस्ड क्वेश्चन के लिए तैयार रहें। हमेशा सेक्शन 126, 132 और 133 के बीच का लिंक मेंशन करें और MC वर्गीज केस को साइट करना ना भूलें।
एक क्विक रिवीजन के लिए बस ये 3 चीजें याद रखिए। हम बात कर रहे हैं सेक्शन 133 की। इसका कोर कॉन्सेप्ट है कि गवाही देना ऑटोमेटिकली प्रिविलेज को वेव नहीं करता। और की प्रिंसिपल ये है कि कोई भी वेवर इंटेंशनल और स्पेसिफिक होना चाहिए। आपके एग्जाम्स के लिए इसकी इंपॉर्टेंस काफ़ी हाई है। और ये है हमारे पूरे डिस्कशन का सार, आपकी फाइनल टेक अवे लाइन। इसे याद रखिएगा, वॉलंटियरिंग एविडेंस डज नॉट डिस्ट्रॉय प्रिविलेज, ओनली इंटेंशनल डिस्क्लोजर डज। ये एक लाइन आपके आंसर्स को एक पावरफुल कंक्लूजन देगी। For more judiciary, APO and law exam focused legal content, stay connected with Ganga Education. If you're gearing up for the judiciary or APO exams, you already know how critical the Indian Evidence Act is. Today, we're going to dive into a really important section, one that protects the very foundation of that client-lawyer relationship. This one sentence really gets to the heart of it, doesn't it? It's not just some rule written in a book. It's a fundamental pillar of legal practice and, more importantly, of a client's rights. So let's break down exactly what this means and why it's so vital for the administration of justice. Okay, let's get into it. Okay, so here's how we're going to tackle this today. We'll break it down into 4 simple parts. First, we'll cover the core principle. Then, we'll deconstruct the legal language of the BEAR Act itself. After that, we'll look at how it's actually applied in court, and we'll wrap up with a focused revision session just for your exams. All right, let's begin. Our focus is Section 134 of the Indian Evidence Act 1872, and at its core, this section is all about one thing: the privilege given exclusively to the client. You can think of this section as a shield for the client. Now, if you remember our chat about Section 132, that was all about protecting the advocate from being forced to disclose information. Well, Section 134 is really the other side of that same coin. It gives that same kind of protection directly to the client. This dual protection is a cornerstone of legal ethics, and, you guessed it, a super important topic for your judiciary and APO exams. Now, you know the drill. Let's look at the exact wording from the source, the BEAR Act. We'll read it, and then we're going to break down all that legal jargon into plain, simple English. So, the BEAR Act says, no one shall be compelled to disclose any confidential communication. What does that actually mean? Well, in simple terms, a court can't force a client to get up on the witness stand and spill the beans about the private, confidential things they've told their lawyer. This protection is solid, but there's one very specific exception we're about to get into. To really get this section, you need to understand 3 key phrases. First, confidential communication. This isn't just any chat. We're talking about information shared in a professional legal context with a clear expectation of privacy. Second, legal advisor. This is a broad term that covers advocates, barristers, pleaders, the whole team. And third, compelled to disclose, which means the court cannot use its power to force this information out of the client. So let's walk through the logic of how this works. It all starts with a confidential communication. That communication is then given protection from compulsion. But, and this is the part you really need to pay attention to, there's an exception. This exception kicks in only when the client voluntarily decides to become a witness. Why? Because the law is about fairness. This privilege is a shield, not a sword. A client can't just tell one part of the story in court while hiding advice that might contradict it. If they open that door by testifying, they waive the privilege, which leads to a limited disclosure about that specific topic. Okay, so we've got the theory down, but how does this all play out in a real courtroom? Let's talk about the practical application of Section 134 and some of the big cases that have shaped how we understand it. Let's imagine a scenario. On the left, a client talks to their lawyer and decides not to testify. In this case, their communication is completely protected. Full stop. Nobody can touch it. But now look to the right. Let's say that same client decides to take the witness stand and starts talking about the legal advice they received. The moment they do that, they've opened the door. The court can then ask for more details to get the full story, not just the bits the client wants to share. Now, speaking of court cases, there's one you absolutely have to remember. It's MC Verghese versus TJ Panan. This case was a game changer when it came to cementing the principle of legal professional privilege here in India. So what did the court say in this case? Well, it held that this legal professional privilege isn't just a rule, it's a fundamental right of the client. The court made it crystal clear that protecting these conversations is essential for a fair judicial process. I mean, think about it. If there's no trust, a client can't be completely honest, and then justice really suffers. You know, the idea behind this privilege connects to an even bigger principle in criminal law, the right against self-incrimination. And this is beautifully captured by the legal maxim you see here, nemo tenuter se ipsum accusare. It just means that no one can be forced to be a witness against themselves. So you can see how Section 134 is a really practical application of this fundamental right. All right, let's switch gears and get to the part you've been waiting for, our exam focus. We'll quickly revise the key points and talk about how questions on this section might pop up in your judiciary and APO exams. So for your exams, this is crucial. You have to see Section 132 and Section 134 as a team. They work together. as the table shows, Section 132 stops the advocate from disclosing information, while Section 134 stops the client from being forced to. Together, they create this complete, totally sealed protection for legal professional privilege. So for your prelims, expect direct questions like, which section protects the client? Or maybe one about that key exception. For the mains, get ready for a problem-based question, perhaps about selective disclosure, or you might get a short note on legal professional privilege. But honestly, beyond the exams, really understanding this is just vital for being an effective lawyer. Okay, for a super quick revision, just lock in these 3 things. 1, the section number is 134. 2, the core concept is the client's privilege against being forced to disclose legal communications. And 3, its exam importance is, without a doubt, high. And finally, if you remember just one thing from today, let it be this. It perfectly sums everything up. Client privilege is absolutely protected, but it can't be used as a weapon or a shield to tell only half the truth to the court. It's all about that balance between privilege and fairness. For more legal content designed to help you with your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education. Today, we're going to zero in on Section 135. Now, this is a really crucial provision, all about witness protection, and trust me, it's a must-know for your judiciary and APO exams. Okay, let's dive right in. So we've broken down this explainer into 6 clear parts to give you the complete picture. We'll kick things off with the fundamentals, then decode the actual legal text, see it in action with some examples and important cases, and finally, we'll wrap it all up with a solid strategy for your exams. Let's get started. So, first things first, let's start with the basics. What is Section 135 all about? Well, at its very heart, its main job is to protect witnesses. But not just any witnesses. We're talking about those individuals who are not actually parties in the legal case themselves. Their only role is to come and give testimony. So what's the core idea here? It's actually quite simple, but very powerful. A person who is a stranger to the suit, meaning they have nothing to do with the actual dispute, cannot be forced to show their private property documents or any other document that could get them into trouble. You can think of this section as a 3-pronged shield. It protects a third party's property rights, their privacy, and their fundamental right against self-incrimination. All right, so we've got the main principle down. Now, let's move on and decode the actual legal language of the section. Understanding the BEAR Act itself is absolutely key. The section says very clearly that a witness who is not a party to a suit cannot be forced to produce their title deeds or any document that might tend to criminate them. In simple language, this just means a court can't force a third-party witness to bring in their personal land deeds just because it might be relevant to someone else's case. Now, to really master this for your exams, you have to know its 4 essential ingredients. First, this protection is only for witnesses who are not parties to the suit. Second, it covers 3 specific types of documents: title deeds, documents about possession like mortgage papers, and anything that is self-incriminating. Third, the general rule is simple. You cannot be compelled. But, and listen, this is the really crucial part. The 4th ingredient is the exception. If a witness has already agreed in writing to produce the document, well, that shield comes down. That written agreement completely changes the game. Theory is one thing, but how does this principle actually work in a courtroom? Let's look at some practical examples and a very important legal maxim to really bring this concept to life. Let's try to put ourselves right in the courtroom. Imagine a few scenarios with me to see exactly how a judge would use Section 135. I think this will make its application crystal clear. Okay, imagine a property dispute between A and B. C is called as a witness. The court cannot force C to show the title deeds to his own land. It's just not going to happen. Similarly, if C is holding some property as a mortgagee, those papers are also protected. Now, what if C has a document that, well, unfortunately reveals he committed some tax fraud? The law protects him. He cannot be forced to produce it. So when does this all change? Only if C had a prior written agreement to produce these documents. Then, and only then, he has to show them. What's really fascinating is the legal philosophy that holds all of this up. It's beautifully captured in the Latin maxim, nemo tenuter se ipsum accusar. This simply means no one is bound to incriminate himself. And this isn't just some old saying, it's a cornerstone of our entire legal system. You'll find its spirit in Article 20, Clause 3 of the Constitution, and it's what gives Section 135 its real power. All right, let's switch gears and talk about one of the most vital areas for your mains exam, judicial precedents. Understanding how the courts have interpreted and applied Section 135 is absolutely critical if you want to score well. A landmark judgment that you absolutely must know is State of Gujarat versus Shamlal Mohanlal Choksi. This case is incredibly important in shaping how we understand this section today. In this really important case, the court directly addressed and upheld the witness's right against self-incrimination. The ruling was perfectly clear. You cannot force a witness to produce documents that could get them caught up in a criminal case. This case really illustrates the practical power of that maxim we just talked about, taking it from a philosophical idea to a solid legal protection. Now, building on that, there are two other cases that are great to remember. The case of N.P. Sharma versus Satish Chandra helped explain the scope of self-incrimination, basically how far it reaches. And then the Kati Kalu Ogad case clarified what it even means to be a witness. Together, these cases give us a much clearer, stronger picture of the protections available, so make sure you remember these names. Okay, let's take a step back and analyze the bigger picture. What was the thinking behind this section? We need to understand why this law exists in the first place, and also be aware of its limitations. Section 135 really serves four main goals. First, to protect the rights of third parties who have no connection to the dispute. Second, to stop the court process from being misused to harass witnesses. Third, to protect their private property interests. And finally, to uphold that fundamental right against self-incrimination. The law is basically doing a delicate balancing act here, right? Between the need to get evidence and the need to protect an individual's liberty. So if we analyze this critically, the advantages are pretty clear. It protects innocent non-parties from being unfairly dragged into someone else's fight, and it helps ensure fairness. But what's the flip side? Well, it could potentially block access to really important evidence. The law sees this, though, and tries to balance it with that powerful exception we talked about, the prior written consent. All right, let's bring it all home to what really matters most for you as an aspirant, the exam strategy. How do you take all this knowledge and turn it into marks? For your prelims, you should probably expect a direct question. They might ask something like, what is Section 135 about, or what is its core principle? It's usually straightforward. For the mains exam, though, you need to go deeper. You could get a problem-based question where they give you a scenario and you have to decide if a witness can be forced to produce a document. Or they might just ask you to write a short note on the protection given to a non-party witness. For quick last-minute revision, just lock these 3 points into your memory. First, the section number, Section 135 of the Indian Evidence Act. Second, its core concept, which is the protection for non-party witnesses from producing certain documents. And third, here's the perfect line to use in your exam answer. A non-party witness cannot be compelled to produce documents that affect his property or expose him to liability. If you can just remember these 3 things, you'll be in a great position to handle any question on this topic. And that wraps up our detailed breakdown of Section 135. I really hope this explainer has made the concepts much clearer for you. For more legal content focused specifically on the judiciary, APO, and law exams, please stay connected with us here at Ganga Education.
We're talking about Section 136, which deals with something called derivative privilege. Now, this is an absolutely crucial section for your judiciary and APO exams, so let's get right into our analysis.
Here's a quick roadmap of what we'll cover in this explainer. First, we'll introduce the section itself. Then, we'll break down its core principle. After that, we'll look at some key case laws and legal maxims. Next up, we'll see how this section fits in with other laws. And finally, we'll wrap up with a sharp focus on exam prep and revision.
All right, so let's start at the very beginning. What does the law itself actually say?
Our focus today is Section 136 of the Indian Evidence Act, 1872. This section addresses a very specific situation. What happens when a privileged document ends up in the hands of a third party? Can they be forced to produce it in court? Let's find out.
Okay, so what does all that legal language really mean in simple terms? Well, imagine you're holding a document that belongs to your friend. Now, if your friend has a legal right, a privilege, to refuse to show that document to a court, then you can't be forced to produce it either. The only way you can be compelled to produce it is if your friend, the original owner, agrees to it.
Now let's really dig into the core principle of this section to understand how it actually works.
The big concept here is called derivative privilege. You might also hear it called extended privilege. And the idea is really simple but powerful. The legal protection given to a document is stuck to it, almost like glue. It travels with the document, no matter who is holding it.
So, for this section to apply in court, a few essential conditions have to be met. Let's walk through them. First, someone has possession of a document. Second, that document actually belongs to someone else who has a privilege over it. Third, that original owner has the legal right to say, no, I won't produce it. If those three things are true, then fourth, that same protection extends to the person currently holding the document. But, and this is important, there is one exception. If the original owner gives their consent, then the document can be produced.
If there is one single line you remember from this explainer, make it this one. Privilege travels with the document, not merely with the person. This really is the heart of Section 136. The protection is attached to the item, not to the individual.
Theory is great, but let's make this more concrete. How does this actually play out in a courtroom scenario? Let's take a look.
Okay, picture this. A client receives a confidential letter from their advocate. We know that communication is privileged, right? Now the client gives that letter to their friend for safekeeping. Later, in court, the opposing counsel tries to force the friend to produce that letter. Can they do it? The answer is a clear no. Why? Because under Section 136, the privilege that protected the letter in the client's hands has now traveled with that letter into the friend's hands.
So, we understand the text of the law. Now let's see how the courts have interpreted this section and what legal principles support it.
A landmark judgment you absolutely need to know in this area is R versus Darby Magistrates Court, Ex Parte B. This case is incredibly significant for understanding how this principle is applied. The main question the court had to answer was this: does legal professional privilege survive if a document ends up with a third party? And the court's answer was a resounding yes. It held that the privilege stays with the document, completely intact, no matter who has possession of it. This ruling is a perfect illustration of the core principle of Section 136.
This whole idea is also captured beautifully in a legal maxim. Now, it's a bit of a mouthful in Latin, but the meaning is simple and powerful. What cannot be done directly cannot be done indirectly. And that's exactly what Section 136 is designed to do. It prevents someone from using an indirect method to defeat a legal privilege. It closes the loophole.
So why do we have this section in the first place? And how does it connect with other parts of the Indian Evidence Act? Let's put it in context.
When you boil it down, Section 136 has four main goals. First, it's there to stop people from finding clever ways to get around the law. Second, it's all about protecting the confidentiality of privileged communications. Third, and this is its unique job, it extends that legal privilege to third parties. And finally, all of this works together to help ensure a fair trial.
You see, Section 136 doesn't stand alone. It actually builds on other sections in the Evidence Act that establish privileges, like the one for advocate-client communications. Think of Section 136 as the final piece of the puzzle that completes the circle of protection, making sure the privilege holds strong even when a document changes hands.
And now, we get to the part you've been waiting for: how to tackle this topic in your judiciary and APO exams. Let's focus on revision.
For your preliminary exams, you should be ready for a direct hit. They might ask a question like, which section of the Indian Evidence Act deals with derivative privilege? Or they could frame a question based on the core principle itself.
So let's break it down. For prelims, your focus should be on the section number and that core principle. Privilege follows the document. For your mains exam, you'll need to go deeper. Expect either a short note on derivative privilege or, more likely, a problem-based question where you have to apply the rule to a specific factual scenario.
All right, time for a rapid-fire revision. Let's lock in the key points. The section, 136 of the Indian Evidence Act, 1872. The core concept, derivative privilege. The key principle to remember, privilege travels with the document, not the person. And its importance for your exams, extremely high.
And finally, if you need one perfect line to summarize this whole concept for your exam answer, here it is. What is privileged in one's hands remains privileged in another's hands. It perfectly captures the essence of the section.
For more legal content and explainers focused on your judiciary, APO, and other law exams, make sure you stay connected with us here at Ganga Education.
Now this one is all about compelling a witness to answer questions, but also protecting them. It's an absolutely crucial topic for your judiciary and APO exams, so let's get right into it.
So, to really get Section 132, you first need to understand the legal tug-of-war it's trying to solve. On one side, you have the court's main job, to find the truth, and for that, it needs witnesses to speak up. But on the other side, we have a fundamental right, the right not to incriminate yourself. Section 132 is the law's attempt to strike a very, very delicate balance between these two powerful ideas.
So here's our game plan. We'll start with that core conflict. Then we'll decode what I call the compulsion plus protection rule. After that, we'll see how it works in court with some case laws, connect it to the Constitution, and finally, we'll wrap up with a quick revision just for your exams. Okay, let's kick things off with our first section. We're going to look at the very foundation of Section 132. Why do we even have this rule, and what is it trying to achieve?
Our focus then is Section 132 of the Indian Evidence Act 1872, and it really answers a very critical question. Can you force a witness to answer something, even if that answer could land them in serious legal trouble? Like, could it get them prosecuted or make them pay a penalty?
Now, the law itself is pretty direct. It says a witness can't be excused from answering just because the answer might criminate them. So, what does that actually mean in plain English? It means if you're on the witness stand and the question is relevant, you have to answer. You can't say, I refuse to answer because it will get me in trouble. The law says, nope, you've got to speak up.
Okay, that brings up a huge question, right? If a witness is forced to answer, what about their rights? Well, that leads us straight to the most important part of this section. It's a principle I like to call the compulsion plus protection rule. If there's one single thing you take away from this entire discussion, let it be this simple sentence. The law demands the truth from a witness, but in exchange, it grants that witness protection for telling the truth. That right there is the whole philosophy of Section 132 in a nutshell.
Let's break down how this works step by step. So, step 1, a lawyer asks a relevant question in court. Step 2, you, the witness, realize the answer could incriminate you. What happens next? Step 3, the law kicks in and compels you to answer. You have no choice. And then comes the most important part. Step 4, the moment you give that answer, you are automatically given immunity. The legal system can't use that statement to prosecute you.
So, when a court is applying this, what are the essential ingredients it looks for? First, the person must be a witness, and they must answer. There's no way around it. Second, relevancy. The question can't just be some random query. It has to be relevant to the case. Third, compulsion. The law forces the answer. And fourth, the payoff, protection. That answer cannot be used to arrest or prosecute you for any crime, with one little exception, of course. You can still be prosecuted for perjury if you lie. All right, theory is great, but how does this rule actually play out in a real courtroom? And what do the landmark cases tell us? Connecting the law to its practical application is absolutely essential for your exams.
Let's take a practical example. Imagine a witness, we'll call him A, is on the stand in a criminal case. During cross-examination, he's asked, "Were you at the crime scene?" Now, A is terrified because if he says yes, he might become a suspect himself. But under Section 132, he has to tell the truth. So he says, yes, I was there. The beauty of this section is that the police can't now open a new case against A based only on that admission in court. He's protected. And this isn't just a textbook idea. This principle has been stamped and approved by the Supreme Court many times. This quote here really captures the heart of it. The courts have been crystal clear. When a witness is compelled to speak, they are also protected because they spoke.
The leading case you absolutely have to know here is Laxmipat Choria versus the state of Maharashtra. The big question was, can you use a witness's compelled statement against them? And the court's answer was a firm no. It held that the proviso to Section 132 offers complete protection. The witness is forced to answer, but that answer is shielded from being used against them in a criminal case.
Now, this whole topic connects to a very famous legal maxim, nemo tenetur se ipsum accusare, which simply means no one is bound to incriminate himself. But wait a minute, you might be thinking, doesn't Section 132 do the exact opposite? And you'd be absolutely right. Section 132 is basically a modification of this rule. It says, actually, you are bound to give an incriminating answer, but as a trade-off, we'll give you immunity. It's a very clever legal bargain.
Okay. Let's move on to something that is absolutely critical for your exams. This is the link between Section 132 and our Constitution, and more importantly, the fundamental difference between a witness and an accused person. This is a very popular area for questions.
You see, you can't really understand Section 132 in isolation. You have to read it alongside Article 20, Clause 3 of the Constitution of India. Article 23 is what gives us the fundamental right against self-incrimination. But, and this is a huge but, the protection under Section 132 is for a witness, while the absolute protection of Article 23 is only for an accused person.
This table really makes the difference pop. Look, a witness under Section 132 must answer the question, but in return, they get immunity. An accused person, on the other hand, under Article 23, has the constitutional right to remain silent. They have absolute protection. No one can force them to say a word. This difference is a game changer, and it's a favorite for both mains papers and interview questions.
And that brings us to our final section. Let's bring it all home and look at this topic purely from an exam perspective, followed by a super quick recap.
So, for your exams, please keep these tips in mind. For prelims, you're likely to get a direct question on the proviso to Section 132, maybe about the scope of the immunity. For mains, expect a problem-based question where they give you a scenario and ask you about the consequences. And for the interview, you can bet they will ask you to explain the link between Section 132 and Article 23. Okay, time for a quick-fire revision. If you're studying last minute, just burn these 3 points into your memory. 1. The section number, 132. 2. The core concept, compulsion plus protection. And 3. Its exam importance is definitely high. Remember these 3 and you'll be in a great position to answer any question on this topic.
So I'll leave you with this final thought to ponder. How does our legal system manage this constant balancing act between the desperate need for truth and the sacred fundamental rights of an individual? Section 132 is, I think, a brilliant example of the law trying to find that perfect middle ground. For more focused legal content for your judiciary, APO, and other law exams, please stay connected with us here at Ganga Education.
So here's a fascinating question for you. Can one criminal's testimony be the only thing that sends their partner in crime to jail? It's a really critical issue in criminal law, and today we're going to dive deep and find the answer, which deals with something called accomplice evidence. Let me tell you, for your judiciary and APO exams, this section is absolutely crucial. Alright, so this is the bare text of the law. Simple language में समझें, तो इसका मतलब है कि an accomplice, a partner in the crime, is considered a competent witness. That means the law says, yes, this person is allowed to testify. And here's the really interesting part. A conviction based only on that testimony, without any other proof, is technically not illegal. To really get this, let's break down 3 key terms. First, we have the accomplice. This is anyone who participated in the crime. But, and this is important, the court sees them as a tainted witness. Their motives are, well, questionable. Second, a competent witness is simply someone the law says is qualified to give evidence. And third, uncorroborated means the testimony stands completely alone with no other independent evidence to back it up. And this is where we find the central conflict of this whole topic. It's a classic case of law versus practice. On one side, you have the rule of law, Section 133 itself, which says a conviction is perfectly legal. But on the other side, you have the rule of prudence, the wisdom of the courts. Judges know an accomplice might be lying to save their own skin, so, in reality, they view this testimony with extreme caution and almost never act on it alone. Okay, suppose एक situation लेते हैं to make this crystal clear. Imagine 4 people rob a bank. The police catch one of them. Let's call him A. To get a lighter sentence, A agrees to testify against his partners B, C, and D. Now, according to Section 133, A is a competent witness, and legally, his story could convict the others. But in a real courtroom, no way. The judge is going to ask, where's the proof? They will look for independent corroboration, CCTV footage, fingerprints, maybe the stolen money found at B, C, and D's houses. A's word alone just isn't enough. So, because of this rule of prudence, our judiciary didn't just stop there. Over decades, through some very important landmark cases, they've developed specific tests. These are the tools courts use to figure out if an accomplice's evidence is reliable enough to be considered. And this brings us to a landmark judgment, Rameshwar versus the state of Rajasthan. The Supreme Court said something profound here. It said that needing corroboration is a rule of prudence, not a strict rule of law. But it's a rule that's followed so consistently, so universally, that it has practically become law. This is the key distinction you need to understand. The law permits it, but judicial practice demands more. Building on that, we have other key cases. In Sarwan Singh versus State of Punjab, the court clarified that you don't need to corroborate every single tiny detail. The corroboration just has to support the material particulars, the main important facts of the story. Then, the case of State of Tamil Nadu versus Suresh laid down even more detailed conditions for when a court can rely on an accomplice's testimony. So, what is this test for good corroboration? It's basically a 3-step checklist. First, the supporting evidence must come from an independent source. It can't be from the accomplice's friend or family. Second, it has to confirm the material facts. It's not enough to prove a crime happened, it has to back up key parts of the accomplice's narrative. And third, and this is the most critical step, it must directly connect the accused to that crime. This is the link that the court is always looking for. You know, there's a legal maxim that captures this entire philosophy perfectly. Testimonia ponderanda sunt, non numeranda. It means evidence must be weighed, not counted. It's all about quality over quantity. One solid piece of independent evidence is worth far more than the testimony of a tainted accomplice. This maxim is really the soul of the rule of prudence. Now, a very important update for all aspirants. The Indian Evidence Act of 1872 has been replaced by the new Bharatiya Sakshya Adhiniyam 2023. So what used to be Section 133 is now Section 117 in the new Act. Please make a note of this. The core principle is exactly the same, but the section number has changed, and you need to know this for your exams. All right, let's talk exam strategy. For your prelims, you can expect direct questions on the new section number, Section 117, and the basic principle. For your mains, get ready for problem-based questions, where you'll have to apply this rule of prudence. And here's a pro tip. If you want to add value and get those extra marks, make sure you quote the Rameshwar case and the legal maxim. The key takeaway is simple. Accomplice evidence is admissible, but it's unsafe to rely on without corroboration. So, for a quick revision, just remember 3 things. First, the section numbers, old Section 133, new Section 117. Second, the core concept, an accomplice can testify, but it's risky to convict based on their word alone. And third, the guiding rule. Always apply the rule of prudence, which means you need corroboration. And remember, the importance of this topic for your exams is very, very high. And that wraps up our deep dive into accomplice evidence. I really hope this explainer was helpful for your preparation. For more judiciary, APO, and law exam-focused legal content, make sure you stay connected with us here at Ganga Education. You know, for judiciary and APO exams, this topic is absolutely crucial. तो चलिए, इसे detail में समझते हैं. Okay, so here's our game plan for today. We'll start with the foundational principle, then we'll break down the rule, see how it works in practice, look at some landmark cases, understand the new legal position, and finally, we'll wrap up with a quick revision focused on your exams. All right, let's dive right into our first section, the foundational principle. यहाँ हम समझेंगे कि आखिर witnesses के नंबर की कोर्ट में क्या वैल्यू है. So let me ask you a very direct question. एक मर्डर जैसा सीरियस क्राइम प्रूव करने के लिए क्या सिर्फ एक गवाह काफी है? Just think about it. The answer to this question is basically the entire essence of this section. And the answer is yes. It might sound a bit surprising, right? But according to Indian law, just a single solitary witness can be enough to prove a crime as grave as murder. और ये principle आता है सीधे bare act से. So here it is. Section 134. It's incredibly simple and crystal clear. No particular number of witnesses shall in any case be required for the proof of any fact. Just this one line holds the entire philosophy. You know, the easiest way to understand and remember this section is through this legal maxim. Evidence is weighed, not counted. इसका मतलब बहुत साफ है. गवाही को तोला जाता है, उसके क्वालिटी देखी जाती है, उसे गिना नहीं जाता. The court is interested in the quality of the testimony, not the quantity of witnesses. Okay, so now that we've got the main idea, let's deconstruct this rule. Let's break it down into its key ingredients so you can understand it even better. Essentially, there are 3 important elements here. First, no numerical requirement. The law doesn't say you need 2 or 5 or 10 witnesses to prove something. There's no minimum number. Second, quality over quantity. This is the golden rule. The court focuses on how truthful, consistent, and credible the testimony is, not how many people are saying it. And third, the single witness rule. This means that if a single witness is found to be completely reliable, their testimony alone can be the basis for a conviction. So the next big question is, how do courts actually apply this principle in a real trial? Let's see how this plays out in a courtroom scenario. A judge generally follows this logical flow. First, a single witness comes and gives their testimony. After that, the court begins its scrutiny, a very careful examination of that witness's credibility and reliability. The judge asks, is this testimony consistent? Is it truthful? Can I trust this person? And if, after all these checks, the court finds the witness to be reliable, then that one testimony is considered sufficient to prove the fact. Let's make this even clearer with a practical example. So imagine there's only one eyewitness to a murder. That person comes to court and gives a very clear, very consistent account of what happened. They stick to their story even during cross-examination. In a situation like this, if the judge believes the testimony is credible, a conviction can happen based on that one witness alone. Now, let's look at how the Supreme Court has interpreted this rule over the years. We'll discuss some landmark judgments that have set the guiding principles for all other courts to follow. If you're going to remember just one case on this topic, make it this one. Bharatiya versus State of Madras. It's the most important authority. The main question before the court was simple. Can a conviction be based on the testimony of a single witness? The Supreme Court said yes, but with a very important condition. The witness must be wholly reliable. Once again, the emphasis was put squarely on the quality of the evidence. Now, in this very same case, the Supreme Court gave a really important classification. They divided witnesses into 3 categories, and this is a hot topic for your exams. The first category is wholly reliable. Their testimony is so good that no extra support, no corroboration is needed for a conviction. The second is partly reliable. Here, the court needs some other supporting evidence to be sure. And the third category is wholly unreliable, whose testimony the court just throws out completely. Besides Vadivelu Devar, there are a couple of other key cases to know. In State of UP versus Anil Singh, the court said that minor contradictions in testimony don't automatically make a witness unreliable. And in Namdeo versus State of Maharashtra, the Supreme Court again upheld a conviction that was based on a sole witness. Okay, let's fast forward to the present. As you know, we have new criminal laws now. So, we need to understand what has happened to this principle under the new legal framework. And here's the most important update for you all. The provision has been kept exactly the same. What was Section 134 in the Indian Evidence Act is now Section 118 in the Bharatiya Sakshya Adhiniyam 2023. The wording is identical, the principle remains unchanged. The only thing you need to update in your notes is the section number. This is a must-know for your upcoming exams. All right, let's shift our focus to the most crucial part for you, your competitive exams. How can questions from this topic show up, and what exactly do you need to remember? For your judiciary and APO prelims, you can definitely expect a direct multiple-choice question on the section numbers, both the old Section 134 and the new Section 118. In the mains exam, you could get a short note on this principle, or, more likely, a problem-based question where you have to apply this rule to a given situation. So, for a quick revision, just lock these 4 points in your mind. First, the core concept, quality over quantity. Second, the key principle, evidence is weighed, not counted. Third, the landmark case, Vadivelu Devar, is non-negotiable. And fourth, the relevant sections, Section 134 of the IEA and Section 118 of the BSA. And as we wrap up, here's a final thought to take with you. Always remember, one truthful witness outweighs many unreliable ones. This one sentence perfectly captures the entire philosophy behind this section of law. For more judiciary, APO, and other law exam-focused legal content, please stay connected with us here at Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share, and subscribe to Ganga Education. Keep learning, keep growing, and stay connected for more law lectures.